So what is happening? I see, does she have the possession with intent 4,200 grams as well?
Judge, I'll be 100% honest. I don't know.
All right, if you could look up to see if she has anything pending other than the theft case, then we'll take it up. All right, so once they look it up, they'll be able to tell me every case. So just give us a moment.
Thanks, Judge.
You're welcome. It's always great seeing you.
Appreciate that, Your Honor.
Although I'm used to seeing you on Zoom with your Oscar or your Emmy behind you.
Judge, that's a very good memory.
Yeah. So how was your weekend?
It was good, Your Honor. Thank you. Thank you for asking. Hope the same is true with you and everyone else in the courtroom.
Oh, no, the weekend was great. I didn't do what Vashawn did, which was go see Meg too. Like, that's on you. She should have saw that one. That's all on you.
Judge, there are two cases, one burglary of a building, and the other one's possession, PD 1, 4,200. Both are awaiting indictment.
Okay. And possession, and that's 4,200?
Yes.
All right, so the other thing the court has is there's an affidavit to surrender surety on the case that's indicted. Counsel, were you made aware of that?
Yes, Judge.
All right, so that was granted on July 19th. So she has a warrant out for this case.
That's my understanding, Your Honor.
Right. And then there's also a motion to reinstate bond on this case.
I was made aware of that this morning. Ms. Rubio informed me that discussions with the surety company resulted in the surety wishing to approach the court to reinstate the bond.
All right, these other cases, the burglary of the building and possession, what are the offense dates on those?
Here, let me check that. I know that they were relatively.
Okay.
Yes, that would have been back in June.
Okay. And then the theft case, let me see what's on the indictment. That's June 3rd. And so you're saying these cases?
So Judge, the theft case, this happened back in June of 22.
Mhm.
The new cases happened in June of this year.
All right. I state if you have no objection to me reinstating her bond, I will reinstate her bond, but I'm going to add other conditions.
No objection to the state judge.
All right, we're going to go on the record. Court is calling 2023 CR 4281A, State of Texas versus Vanessa Faye Rubio. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Your Honor, good morning. Frankie Sandoval on behalf of Ms. Rubio.
And are you Miss Rubio?
Yes.
On this case, there was an affidavit to surrender surety, and the court granted that on July 19th, it looks like. And now the bondsman has just filed a motion to reinstate the bond. Any objections from the state to reinstate the bond?
No, Judge.
Ms. Rubio, I have to ask you some questions if I'm going to reinstate this bond. The questions I ask you will not be about the underlying facts of the case, but I do need to ask you other questions. So could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give would be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. I'm going to need you to speak up so the court reporter can hear. State your name for the record.
Vanessa Faye Rubio.
All right. Ms. Rubio,
Ma'am.
have you had any mental health treatment before? Any diagnoses of mental health? Drug use? Oh, if I drug test you right now, what are the results going to be?
Negative.
Okay. All right, we'll do a drug test and then we'll come back. And the reason why I'm doing that, because the law has changed. If I'm going to be setting bonds, I need to make sure that there are conditions in place so that you won't reoffend. For example, if you have a drug issue and I know about it and I don't do anything about it, that comes back on me for not addressing that issue. So counsel, we'll do a UA today. And if there are no issues with the UA, then I won't add conditions of treatment.
Thank you, Judge.
All right. So before we do that, you're saying it's going to be negative. All right, could you hang? They'll give you a UA today. And then Mr. Sandoval will take that up.
Thank you, Judge.
Hi, it's always great. So where are we on this case?
We'd like a trial, Your Honor.
All right, so the last time we were here on July 5th, it was for him to be considered for Veterans Treatment Court. Are you a veteran?
Yes.
All right, so what happened with that?
Well, he said that he was in the service for 4 months and
No,
then.
no. What happened with his
That's what I said.
Veterans Treatment Court? Did you go
He
get
says
interviewed?
he's not eligible for veterans benefits. That's what I was trying to say.
So,
I don't receive no benefits from the court, I mean, from the
Veterans.
veterans.
are they saying you were dishonorably discharged?
I wasn't dishonored, discharge, it was other than, but I wasn't able to get in contact with them, for the whole month of July. I was at crisis for a week, and then the last 2 weeks, I was at.
All right, so this is what we're gonna do. I'm gonna have you take a seat. We're gonna have somebody from Veterans Treatment Court come down, okay?
Okay.
All right, so if you all have a seat, we're gonna have someone from Veterans Treatment come down to speak with you.
Okay.
All right, so just have a seat and then we'll take this matter up.
Thank you.
You're welcome. All right, thank you. All right, if you'll. Mr. Kirby, could I see you? You've always dressed appropriately for court. Thank you very much.
Appreciate that.
So how are you feeling today?
My vision is real off.
All right, so here's the thing. Probation gave all of the information to me about you. You need to stay on top of your doctor's appointments. You understand?
Yes, ma'am.
Got to eat right.
Wow.
Because otherwise, I read the reports and they're saying some of your illness is off the scales, out of control. And if you don't get that back in control, it's not going to go well. And I know sometimes people don't like taking their medicine. Sometimes people don't like eating right, but you pass that stage, you're going to have to eat right. You understand?
Yes, ma'am.
And also I understood from the report that's given me to probation is that you completed everything.
Yes, ma'am.
So what did you learn? Other than you don't want to be back in a court for this anymore.
I just a lot, for one. I mean, I can't even explain it. And
Everyone, please whisper. Yes.
it's just the classes and stuff and everything like that. I'm a father. You know what I'm saying? I raise my kids. You know what I'm saying? And it helps.
And did the parenting give you new ideas about things, the parenting classes?
Yeah,
Yeah.
it did. It opened up some things for real about, you know what I'm saying, control and everything like that, dealing with the kids and everything like that. It was an experience. It really was.
All right. Well, congratulations on sign the motion for early termination. So you'll be off probation. You're always welcome to come back and visit court. We're here every day. Don't come back with another case, but you can just come back to pop in and let us know how you're doing.
I'll be back then.
All right. And take care of your health. All right. People are dependent on you.
Yes, ma'am.
All right. Good luck to you.
Thank you.
Here's that one, and that's an early termination. Jacob Escobedo.
Good morning, Judge.
Good morning. Where's your client?
He, I guess, is on bed rest. He had like bypass surgery or something. It's my understanding. I told them to make sure if they weren't going to come, that they fax some type of proof of that to the court. I'm not sure what they had faxed.
Do we have?
Yeah, congratulations, somebody. It should be
Okay.
filed.
All right, let me see.
They didn't, so I haven't seen what he had sent. I just explained to him that the court probably wasn't going to take his word for it and that he needed to send proof.
Oh, yes, we always need to have documentation. All right, they say that having him come to court because of the heart surgery would cause undue stress. No, I mean, I understand.
Yeah, it's not unreasonable.
All right, so you say he's on bed rest?
It's my understanding he had like a heart attack and had to have a bypass surgery and was in the hospital for about a week. I think
Alright.
it's just maybe this weekend or
All
Thursday.
right, Ms. Ferguson, on Jacob Escobedo, reset this for 30 days, please. And we'll see where he is.
Sounds good. Thank you.
Good morning. Are you ready? All right, court is calling 2021 CR 11705, State of Texas versus Luis Angel Alvarado. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Scott McCrum from Mr. Alvarado.
And are you Mr. Alvarado?
Yes, ma'am.
All right. Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, and I have.
Court will find that the state is in compliance with discovery. Mr. Alvarado, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
Judge, we're going to proceed on paragraph A.
Any objection?
No, Your Honor.
Mr. Alvarado, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of murder? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Do I intend to?
Did you intend to give up those rights I've explained to you and enter into a plea bargain agreement?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Alvarado, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right. According to the plea, punishment is to be assessed at 15 years in the prison. There's an affirmative finding of deadly weapon. There are no applications, and the state will take in consideration 2021 CR 11704. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to offense as stated in count 1, paragraph A, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State any evidence to support the defendant's no contest plea?
State offer states exhibit 1 and all attachments.
No objection.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments. State, is the complainant's family aware of this offer?
They were made aware.
All right, court will review state's exhibits 1 and attachments. This is the case that was previously tried, correct?
Correct, Judge.
All
Yes,
right.
Judge.
So I'm aware of the facts of the case, and I've read state's exhibits 1 and attachments, and the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
All right, anything you wish to say on behalf of your client?
No, Your Honor.
Anything from the state?
No, Your Honor, although there are victim impact statements that I was notified the family did want to speak.
Okay. All right, then the court will follow the agreement. The court will sentence you. Excuse me, just one moment. All right, the court will sentence you to 15 years in the prison. Give you credit for any time served. There's an affirmative finding of deadly weapon. Court will take in consideration 2021 CR 11704. Is there anything else with regards for sentencing from either side?
No, Your Honor.
Very much.
All right, Mr. Alvarado, I'm going to show you what's entitled Trial Court Certification of Defendant's Right to Appeal. Did you review that with your attorney?
Yes, ma'am.
Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Okay.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So, Mr. Alvarado, I do remember your case. I hope that you've learned this is not the way to settle problems. I was able to see the video. And of course, when you're in the midst of things that are happening, maybe your reaction is different from, I say, people who are sitting in the peanut gallery who are able to look at things dispassionately.
Yes, ma'am.
But, leave, call the police. You understand?
Yes, ma'am.
All right.
Thank
And
you.
were any of those tattoos very painful for you?
The fingers,
And you just did not stop?
I didn't finish. Them.
So you're gonna put more on there?
I'm done.
Okay. All right. So what's gonna happen now is there's gonna be victim impact statement to you. In this court, I require that everyone treats everyone with respect. So victim impact will be given to you respectfully, and I expect you to be respectful back.
Yes, ma'am.
Internalize what's being said. You understand?
Yes, ma'am.
And Judge, it's going to be our victim advocate who's going to read the statements.
All right. So the victim advocate is going to read the statements. All right. So he was here, he was supposed to be interviewed by Veterans Treatment Court, but then something happened mentally. And so if you could make a connection with him.
Okay.
All right. He says that he wasn't dishonorably discharged.
Which isn't a disqualifier.
Yes.
Okay.
So he'll tell you what's going on with him. And if you could let me know when you all will be able to interview him, and I'll recall on an appropriate date.
Yes, ma'am. I'll let you.
All right. Thank you.
What's the next option? That's what-
All right. Juan Carranza.
Good morning, Judge.
Good morning. How are you doing?
Good. Can I give you a heads up of what's going on?
Yes.
Okay. So we were here for a discovery compliance. This was a case where they had requested DNA.
Yes.
The Texas DPS crime lab.
Mhm.
The DNA finally came in late June.
Mhm.
I just discovered it on Veripic
Okay.
last week. So I have asked for and filed a motion for a expert witness, if I could approach and just hand you this.
Yes.
I did e-file it, but I'm never sure if it gets to the court's file. So that's what we're here for today. The state has received a copy. I don't think they have any objection to it. And just to remind the court, I'm the second attorney on this. This is only like my second or third setting.
Oh, no, I have that
Okay,
listed
I
here.
just didn't want you to look at the offense statement.
Mine's a steel trap.
Okay.
Once my mind is not a steel trap, everybody let me know. But no, I have that. We were waiting for labs. So you have the DNA test results.
There's a test, they did produce a result. I don't know that my expert is going to be satisfied with the result because it doesn't really include, usually they have all of the testing numbers. This one does not. It just mostly has conclusions.
Okay.
So we may need to request from the state some additional discovery packet from DPS, but we will definitely get with them in a timely fashion.
Okay.
And I'll go ahead and send a request for the discovery packet because I'm sure he's gonna need it.
All right. So what I'm going to do is I'm going to recall this in 45 days
Okay,
and everything should be in place. You all should be coming back. And the only thing, defense, hopefully, that you should be coming back and telling me is my expert is reviewing it.
okay.
All right, Ms. Ferguson, if I can have a 45-day reset on Carranza for discovery, please.
September 21st.
September 21st.
So we'll be back on September 21st. Do you have any questions, Mr. Carranza? All right, so that's what we're waiting on, DNA. And I always tell people it's better that your counsel have what they're requesting as opposed to going to trial and not having it. I know you've been in custody for a while, but she is not the first attorney. So I will see you all back in September. All right, so what is happening?
Morning, Judge. So we've conferred today and there's a certain witness that we've asked the state to try and track down. I think Mr. Banks is going to try and see if there's any evidence of that anywhere.
Yes, the state will try to track down that.
All right, Ms. Ferguson, they're coming back tomorrow for jury trial.
And Judge, we haven't filed anything yet. We are supposed to be picking in the 186th in 45 minutes.
All right.
So we're set. I haven't filed a motion because obviously we're not in trial yet,
Mhm.
but we're specially set on a murder case in the 186th. We've got to be there at 10.
All right, who is we?
Myself, Jason Goss, and Mr. LaHood.
All right, Ms. Ferguson, recall this for tomorrow and we'll see where we are.
Thank you, Judge.
All right,
Appreciate it.
you'll get a reset form, then you're excused.
To be excused for today, Judge.
Yes, after he signs the reset form. All right, thank you.
Morning, Your Honor.
Good morning. Where's your client?
Coming.
I don't know why people approach without their clients. They have to be a part of this. And if you all could spread out, she's in the center. All right, what is happening with this case?
Your Honor, we've made a request for blood discovery. I think that's an order that needs to be signed still. We
Has
have,
the order been filed? Has the motion been filed?
I believe so, yes.
Has the motion been filed on blood discovery? Let me see. All right, State, have you had a chance to review?
Judge, I spoke with defense briefly. I could say we weren't going to be in agreement on the motion for blood discovery.
Yes.
Oh, yes, we're in agreement with that. Yes.
Okay,
I think we're just waiting for it to be signed
okay. And what are you not in agreement with?
on modifying the bond conditions. Your Honor, defense has filed the motion.
We filed a motion, Your Honor, to modify the bond conditions, but we can get that set for a hearing.
All right, what are you requesting with modification?
So Ms. Schnitz is currently on full GPS. She's being monitored by Scram and by her ignition interlock. We're just asking for a curfew of 8 p.m. so that she'd be allowed to drop off her daughters at school and pick them up and go to work. So all we're asking is from 7 to 8 p.m. She'd be allowed to be on tracking only and then come home. But she is being monitored by Scram. She's being monitored by the ignition interlock. She's also on the drug patch and being required to do urinalysis. If we could waive the urinalysis and just have her do the drug patch, this is extremely costly to her. That would help us out also.
All right, so we'll set that for a hearing. But Norma, on this case, can you recall it in 45 days? And just put it at discovery?
And Judge, sorry, if I may, can I get a copy of that blood discovery motion so I can make a copy in the back so I can send it?
Sure.
on?
I think it, September 21st.
Sure. I'm sorry, what day? And then they want a hearing on a bond motion modification.
I need the motion and then I'll set it since I receive it.
All right, so she'll give you a reset form for September 21st. Is there anything else?
Nothing further, Your Honor.
All right, once you sign that, she's excused.
Thank you.
You're
Thank you,
welcome.
Judge.
You're welcome.